Obviously, I think Iowa. Beth, do you guys do Iowa and Nebraska?
Yes.
Okay, because I'm going to talk about Iowa and Nebraska, and I know we've got some folks here from Amerishore that likewise do both states, and then a few other folks who are probably here to listen to Kansas, which, just FYI, will be John. And once I get done with Iowa and Nebraska presentations, he'll start in on Kansas. So if that's what you're primarily interested in Kansas, I'll be done in about 30 minutes. So feel free to come back then if you like. Might as well.
You're doing Nebraska too?
So Iowa and Nebraska, right. And I'm going to start with Iowa just because typically that seems to be the more controversial state, the one with the most questions, although Iowa and Nebraska are actually probably more similar to each other than maybe any other state. They're not anything like Kansas or Missouri, but they are pretty similar to each other, both with regard to the process, how the work comp claims go through the legal channels, as well as the laws that govern our work comp there. So a lot of the things will be pretty similar. There's obviously some differences since it's a small group and I kind of know everybody. Feel free to jump in at any time with any questions. I'm probably going to kind of fly through the PowerPoint in the booklets. You don't have the PowerPoint, but you do have case law updates, which is just kind of a handful of fairly recent cases with some interesting decisions, some decisions that kind of address questions that come up more frequently than others. As most of you know, a lot of what we do is governed by the decisions in these cases rather than the statute book, which is, not nearly as, I guess, all-encompassing as all the cases that come out year after year. So let me kind of use the PowerPoint here as a guide. We'll kind of go through this. A quick note on surveillance, because we've got it in one of our cases that Marguerite is not handling anymore. But I get a lot of questions on should we do surveillance, and then if so, when we get it back, what does it show, and is it worth it? I'm just now wrapping up a case where it was a compensable injury, pretty simple back injury. Surgery was needed, but long story short, they decided to follow this individual around, see if he was working anywhere besides the employer, who was not able to bring him back to work. So they assigned an investigator, followed him, saw him walking to a place of employment, and based on that surveillance video and the report from the investigative company, denied his claim from then on out because they thought he was working and he had represented that he wasn't able to work. Fast forward to the day, probably almost 18 months later, when I get the claim, still being denied, and we eventually start talking about a settlement, and I'm deposing the claimant, and prior to deposing it, I send them our surveillance information with a picture of this gentleman, and 5 minutes later I get an email from the claimant's attorney. It says, well, that's a great picture of my client's brother. Do you have any of him? And yeah, wrong guy. And they based their denial almost entirely on that for a year and a half.
Wow.
During which time bad faith was mounting, big time. I went on Facebook shortly thereafter and found the guy, and it wasn't the same guy. It took me 5 minutes to realize that they had the wrong guy. And the investigator, they had the same initials, JD, and I think for whatever reason, they found a picture of the guy, thought it was him because he had the same initials, but nobody bothered to look at it that actually knew the kid. Nobody at the employer ever bothered to look at the picture to say, nope, wrong guy, that must be his brother. No one bothered to call this place of employment where he was going to verify that, yeah, he actually worked there. It was a mess. So be careful on surveillance. I often get a lot of clients who call and say, I got this one. I'm trying to remember if it was one with you, Marguerite, that you asked me about one time, where somebody saw the injured worker out of the bar, and they were drinking beer. They were lifting beer with their hand all night. How can she have carpal tunnel if she can? This was a question. How can they have carpal tunnel if they're holding a beer and drinking all night? Well, okay. You want me to walk in and use that as a defense with a judge? Then you're going to be there with me, because that's just not going to get you anywhere. So you get a lot of.
What are the consequences in that first case? I mean, what does he have additional damages or?
They were very seriously threatening a bad faith and interference with insurance contract relationship.
So are there damages?
If they can get it in the right jurisdiction, yeah. And by way of example, which I might have mentioned to you guys at one point in time, this firm actually in particular has a habit of doing so. And in Iowa, they recently won a bad faith judgment of $25 million. Much different circumstances, but that was actually for a compensable injury, which they had been paying. Long story short, they just didn't pay as much as they thought the claim was worth. And they got hit with a $25 million verdict, which is being appealed, but nonetheless.
What was the basis of that?
That was, so the person was perm total. And it was pretty clear that he was going to be eventually. They were paying weekly benefits because they either had an impairment rating or something that they were paying in accordance with. So they kept paying, but claimant's attorney was alleging perm total. I believe they filed a commutation for benefits so they could get it all at once. Defendants resisted, and I think appealed once that was granted, and really just kept trying to fight all the way along and not kind of admit that this was perm total. And that was the gist of it. I mean, I didn't read all of the facts of it, but just because they kept denying that, no, this guy's not perm total, he's not, when everybody knew he was. And I think one thing that kind of sunk them was someone high up the chain in his deposition was kind of asked the question about what's your company worth, and he said, "Oh, we're worth $35 billion. This claim doesn't mean anything to us." Wrong thing to say. So yeah, and that obviously came out in front of the jury. So he didn't do them any favors. So yeah, you don't want to risk bad faith based on surveillance of the wrong guy. So that's why I'm very hesitant to, put too much stock in surveillance. The other thing is, what does it really show? In one case we're dealing with now, we got video of a guy getting out of a truck and walking into a house. What's he doing in there? Why is he there? All very questionable issues that are upsetting the employer. They think he should be, convalescing at home. But all the video actually shows is him driving and walking. But yet they are getting wrapped up in why he's there and what he might be doing there, which might be valid questions. But as far as what the surveillance shows, it's not really getting you where you want to go. So,
What is an effective surveillance, in your opinion? Somebody actually doing
somebody who got I've represented only 2 or 3 plaintiffs in my life, one of which who got caught on surveillance moving himself out of his apartment and carrying furniture.
Yeah.
That's good surveillance.
Yes.
And I let him know that he shouldn't have been doing that.
We had a disability claim on a pension once, and it was a back injury, and they got the guy let go.
Yeah,
So that
playing a sport,
Yeah.
absolutely.
Oh, yeah.
But going to the grocery store,
Oh, yeah. Walking
doing mild yard work, yeah, I mean, you carrying a dresser out of your apartment, that's good stuff. Other stuff, not so great. And it's tough to get good stuff. You have to get lucky more than anything. So,
Okay.
so anyway, surveillance, yeah, be careful with it. I'll scroll through here pretty quickly. Medical care, the main points to to be cognizant of in Iowa are that you get to choose the provider, not the care that they provide. Big distinction, but big stumbling block. There was just I'll kind of get to that in a minute. There's some cases on that I'll talk about. If you start second guessing the authorized treating doctor whom you have chosen, you run into trouble, is the quick version of that. If you decide to stop authorizing treatment, they've reached MMI, they've gone back to work, they seem like they're getting better, that they don't need any medical care, let them know. If you don't, and 6 months down the road, and this is a case that's not in the materials but just came out, and they go back to that authorized treating doctor to seek more care for the compensable injury, and you haven't told them that they can't, you're going to be on the hook for it. In this case, this is a case that went up to the Supreme Court. That's basically what happened. About 6-8 months down the road, injured worker went back, treated for several months, so racked up some pretty significant bills, and the defense was, we didn't authorize it. And you should have known that we hadn't authorized it. The court basically said, well, A, they had no reason to know that you weren't going to authorize it. You never told them. There was never any letter from the adjuster, any communication that would indicate that we're not authorizing any more treatment. So unless you do that, the tap is still on, basically. And it's just for compensable treatment. It's not for unrelated issues, obviously. But if you feel that is going to be an issue, you need to make the employees aware that no more treatment will be authorized unless you come to us and ask. And just reaching MMI doesn't end their ability to get further treatment at all. They're entitled to lifetime medical care as long as the authorized treating doctor thinks it's necessary. And that's another kind of point of contention. Might be different in some states where, well, he's at MMI, can we stop all medical care? No, not unless his doctor says so. So that's kind of the other big stumbling block that often happens in Iowa cases. Causation is often another stumbling block that those of you who are not too new to Iowa are painfully aware of. It's basically just has to be a substantial factor. It doesn't have to be the substantial factor. It doesn't have to be a prevailing cause like you have in other jurisdictions. Be careful what those doctor reports say and what they don't say. The claimant's attorney is always going to get their doctor to say the accident either caused or aggravated his condition. Very often the treating doctor will just say one way or the other, did it cause it? And he won't address the aggravation part of it because they're just not used to doing that. They don't think it's necessary. So that's something that I often have to follow up on. I just wrote a doctor a letter the other day trying to clarify that point. So aggravations, very much just as compensable as acute injuries, so be aware of those. This is a little slide, obviously, stating some obvious facts about things that have an impact on many of the claims: aging workforce and only getting older, smoking and its effect on health. FCEs is something that can be kind of difficult to deal with because of the impact that the results might have on the injured worker's ability to go back to work. If you have someone who is morbidly obese and has basically no physical capabilities before this injury, they're not going to do good on an FCE at any point in time. They may have a lot of comorbid factors affecting that FCE, but how do you differentiate or how do you split those between what was caused by the injury and what is just his natural physical condition? The FCEs don't usually address that. Maybe they should. I don't know if many physical therapists would feel comfortable breaking that down, but unfortunately we're stuck with the restrictions that come from it that maybe the injury didn't necessarily contribute to very much. So one thing that I've been really kind of mulling around a little bit is, rather than having a complete FCE done, perhaps just considering a job site analysis and presenting the physical therapist with the physical restrictions or the job duties of this particular job and getting clearance. Can this person actually perform these job tasks? If so, great, bring him back to work. If he only needs to lift 40 pounds, I really don't need an FCE that says he can only lift 80, because that looks like it's limiting. but he doesn't need to lift 80, so why ask for that? Is just kind of one thing that might be something to consider, especially when you've you got somebody in a rural job, and if they can't go back to that job, they're going to be out of luck, which obviously in Iowa is often the case. Let's see. I'm going to fly through these slides. Feel free to ask questions anytime. Industrial disability is kind of a big nightmare that is often hard to estimate. Here's my Donald Trump slide. So, and penalty. I kind of want to touch on some of the cases that are mentioned because a couple of them are pretty important. IMEs are often they're used pretty frequently, both in Iowa and Nebraska. In Iowa, you're entitled to a second opinion. The claimant is entitled to a second opinion on an impairment rating. Okay, so if your treating doctor for a compensable injury says the injured worker has a 5% disability, you then have to pay for a second opinion on that impairment rating. Sometimes questions will arise as to when they may or may not be entitled to that. And in one of the first cases, the treating doctor didn't comment on impairment. So the defense was, well, there was no impairment rating, so why should we have to pay for a second opinion? Well, that doesn't go very far. And I think in this case or one of the others, the claimant's attorney reached out and asked for that impairment rating, and the defense tried to argue that, well, then it wasn't our rating. He already got his second opinion, so to speak, because he asked for it. That's not going to fly. It was your doctor. If your doctor says X percent, it doesn't matter who asked him for that opinion. Okay, so they're still going to have to pay for a second opinion, IME.
Bill?
Yes.
Real quick, is there any limit on how much they can charge for that or anything?
Yes, but I can't tell you exactly what that limit is. It's case by case, $2,500 is not too much. $3,000 might not be too much. It's often going to depend, how many records does the IME doctor have to review, which in my opinion, to some degree is irrelevant because you're only performing a physical exam to address impairment. Arguably, you don't need to look at 200 pages of past medical history, but they let them. So, if it's a relatively simple case and you have a $5,000 IME bill, yeah, I'm going to fight that. Definitely, if it's a carpal tunnel, something like that. There's no hard and fast limit on it. It's just whatever a judge feels is reasonable to, perform this evaluation. So you don't often see them rejected, mainly because claimants' attorneys typically use the same guys over and over and over and over again, and they all charge the same amount. So. Another big ticket item, when can I stop TTD benefits? One of the cases in there, Ratliff v. Sherwood. Long story short on that one, the claimant was not attending IME appointments. Basically just no-showed 2 of them, and finally did attend the 3rd one, and the insurance carrier wanted to deny him benefits during the period of time where he wasn't showing up, basically from day 1 until he finally did show up. You can do that to a certain degree. You can suspend benefits, and that's what this case talks about. But once he goes back to that IME, or once he attended the 3rd appointment, then you got to bring him current, basically. So he doesn't lose those 2 months or whatever the period of time was, maybe it was longer, during the time when he was no showing appointments. There's no provisions, and the courts have said this isn't the first case to say this, over and over again, that it basically has to do with lack of compliance with medical care. Okay, so you can suspend their benefits, but you will eventually have to reinstate them and bring them current for that period of time. Seems very unfair, since if they're not cooperating, why should we have to pay them? But it's one of the things that kind of makes you scratch your head in Iowa, and that's pretty similar to Nebraska too, as far as when can you stop TTE benefits. There's a case that I know we're kind of familiar with, where you have to pay even if the individual goes to jail. You don't get to stop benefits. So that was a Nebraska case, and it's in there. Another case in Iowa that came out, and this is kind of something that I'm always cognizant of because there's often, I don't want to say a rush to get an IME, but sometimes I think people think an IME is a cure-all, you know. We don't know what to do with this claim, so let's get an IME. And that may be of some benefit, but this particular case is a Nestle USA case. They had an IME done, but they must not have liked it because they didn't get the report, or if they did get the report, they didn't disclose it. And the judge basically drew a negative inference from that. Basically thought, okay, you must not have liked it. It probably said something in favor of the claimant, and we're going to make that assumption and essentially use that as part of his decision-making process. So if you have an IME done, just be cognizant that if you don't like the results, you're going to be stuck with it. And if you don't disclose it, that's going to be something that can be used against you. That's why occasionally I might go the route of just having a records review done, which is not something that we necessarily have to disclose because it doesn't involve an examination in person of the injured worker. The weight of that is obviously not going to be as great as an in-person evaluation, but it may be something at least to give you some guidance on. While I'm on that topic, there's another case in here that kind of touches on the use of UR reports, utilization review, which some companies use more than others. I know that's a hot topic. The quick review of that issue is that Iowa judges view them for what they usually are, which is just an in-house medical report. They don't carry much, if any, weight. They can be a helpful tool to guide you through the process, and that's understandable. But especially in Iowa, where you're already allowed the right to choose the medical provider, if you don't go along with those recommendations, and there's some cases that talk about what happens when you don't, when you try and base your decisions on an outside physician who's never seen this patient, and then you deny treatment based on that report when your own doctor is saying otherwise, you will not win that argument. Okay, the claimant's attorney will file an alternate care petition, and there's a couple of cases in here. One in which surgery was recommended. The defendants wanted to postpone it while they had an IME done. And long story short, the judge said, no, your doctor said surgery, he gets surgery. You can have your IME, but you're not going to delay the treatment, okay? Because it was your doctor and you picked him. And they basically filed an alternate care petition and won. So, you know, caution on the use of IMEs. Sure, you can have them, but how useful are they? And that was the Punt de Jong Farms case, I believe. You cannot place an injured worker's care on hold while you investigate further when you've already got your authorized doctor saying one thing. Another case dealt with the same kind of things. The machine and tool case, they wanted to do a job analysis and an IME prior to approving surgery. Again, you can do that, but you better do it before the doctor wants to do surgery. Because once they've indicated that they want to do that, the claimant is entitled to it. And then the Jones versus American Greetings case, that's the one that dealt with a utilization review report, I believe. Okay, so those are some noteworthy Iowa cases that I admittedly kind of flew through since our time is short. With regard to the Nebraska cases, I guess there's a couple that, one in particular that comes up from time to time. It's a Aurora co-op case, has to do with social events, and occasionally I'll get this question, you know, the injured worker was hurt at a company picnic. Do we have to pay for that? Okay. And there's basically a three-prong analysis in there. There's three factors that the courts will look at to determine whether or not this company event, an injury taking place during that, would be compensable. And you can look at that for some guidance on that. Most of them are pretty common sense. The gray area often happens when you're trying to determine if your injury kind of falls under the third category, which is the employer deriving substantial direct benefit from the activity. And that's a tough one to answer. And you really gotta know a lot about the activity. I mean, just I suppose your typical volunteer company picnic. It's not mandatory, and there's really nothing but good morale that you get out of it. That's probably not going to be a compensable event, so to speak, but certainly some of them can be. The Marshall case was kind of interesting, and it just kind of shows you how liberal, I guess would be the word, or some of the judges can be in Nebraska. You basically had an individual who had a left arm injury that developed into complex regional pain, went up into his shoulder and his neck, and eventually impacted his other arm. He got an impairment to one of his arms, the one that was initially injured, but the doctors didn't give him any impairment to his other arm. And the question basically was, do you need an actual rating of impairment in order to get benefits for and be evaluated for an injury to the other arm? And the court basically said no. The medical evidence supported that there was an injury to the other extremity, and so they were entitled to be, evaluated accordingly for their disability. And basically, in that case, they got a vocational rehabilitation analysis done, which is what happens when you have a body as a whole injury in Nebraska. If you injure both arms in the same accident, it kind of jumps up into a new realm beyond your scheduled member benefits. So that is a crash course in some of the Iowa cases and Nebraska cases. I'm going to go back here, if you'll permit me to scroll back and hit on a couple of items. And I know I've probably mentioned this to some of you in phone calls and emails before, but I'm going to say it again, which is the Form 50 is both the easiest thing to get out of the way and the cause of more headaches in Nebraska than, well, I don't want to say than anything, but certainly it's a simple thing that ought to be done way more often than it is. Many employers don't know about it, and so I understand why they then don't comply with the rules. Many employers do know about it and choose not to comply with it because they want to direct care. What Form 50 is literally a form that says, injured worker, you have the right to choose who you're going to treat with. If you'd like to exercise that right, put the doctor's name here and give it back to us. Okay? You have to do that after the injury. When they're filling out their new hire paperwork is not the time to do that. That doesn't count. It only has to be after the injury.
Bill, what's a reasonable time?
Reasonable time is whatever you and I agree is reasonable time. One of the, like so many other things, it depends. It depends what a judge thinks is a reasonable time. So if he's in the hospital and you can't get to him, the employer, then you need to allow for a few days at least for him or her to get that form and then give it back to you. If you've given it to the injured worker, and when I say you, I mean the employer, but you certainly can, and 4 weeks go by and they haven't given it to you, then I would argue that's too long. They should have gotten it back to you, and so now we're not going to allow you to just treat with whoever you want to. Once they do indicate someone on there, or once they say I don't have anyone and you can pick the doctor, then if either of you want to change, you have to agree. You don't get to just change. And as we know, they get to pick their surgeon. So if they're going to have back surgery, for instance, they can drive back to Lincoln from Illinois and do that with the surgeon of their choice. So it's not a sore spot at all, but that's what they get to do. So major surgery is the caveat there, but there aren't too many minor surgical procedures that would not fall under this. There's another case somewhere in there, and I can't remember if it was Iowa or Nebraska, but I just thought of it. I often get calls for a hernia. Okay, how much is a hernia worth? Well, in Iowa, it was worth 30%, according to one case. It was initially worth 60%. The trial judge said 60% for a hernia, and the guy went back to work. But he had some ongoing complications. They appealed it, but it only got knocked down to 30%. And the doctor's impairment ratings were only 5% to start with. And this is industrial disability. So an extra 25% is 75 weeks, something like that, but it's a lot of money for a hernia. The gentleman was older and lost his job, but it was unrelated to the accident. So he got 30% for an injury that did not prevent him from going back to work. So yeah, with 5% impairment ratings. Frustrating to say the least. That's higher than I've ever seen for hernia. I've had hernias go to trial and they didn't come back that high, but I saw that and I had to include that one. Stopping TTD benefits, kind of talked about in Nebraska. Just because they quit, go get another job, and that employer cannot accommodate their restrictions, they get TTD. Just because you could have, but their new employer cannot, doesn't let you off the hook. Another frustrating Nebraska part of the law. Vocational rehabilitation is much more prevalent in Nebraska. It's not a formal process that is used in Iowa. In Nebraska it is, and if you want me to talk about that in the last few minutes, I certainly can. We use vocational rehabilitation counselors to work through the process, which can often include just job placement services. It might include sending someone back to school. Community college, learn how to be a HVAC technician or whatever. So that's pretty common in Nebraska, the use of it. And obviously you pay for TTD during the pendency of that plan, which obviously can be much more expensive than their PPD rate might have otherwise been. On settlements, I'll mention this in Nebraska because this might come up before, let's say I get a referral. Let's say you've settled a claim in Nebraska and you send it to me to drop the paperwork. And the injured worker is not back to work yet. He's been looking for a job and he can't find one. That's going to be a problem. They can waive their entitlement to vocational rehabilitation benefits, but the court is the mother of all babysitters when it comes to that, and they will heavily scrutinize any waiver of voc rehab. So you've got to have a very good reason why this injured worker who's unrepresented and not working and can't find a job is waiving his entitlement to voc rehab. So that's tough, and I've got one pending now, so we'll see if we can get that one through. So that's kind of a big deal. They need to be back to work or awful darn close if you want to get an unrepresented claimant's settlement through in Nebraska. Iowa doesn't care. You can settle pretty much anything in Iowa. So, and it's very simple in both states, as most of you know. You don't have to go to court, so it's much less burdensome for the injured worker. They just have to read and sign the documents, and then we send them all in. So I'm probably starting to eat into the wonderful world of, oh wow, you told me to keep talking.
Keep
so
talking. You're fine.
I think he's got ulterior motives there as far as why he wanted me to keep talking.
I don't think there are very many Kansas people here.
Somebody came back, so I want to be fair to the Kansas folks here. Any other questions before I sign off? And I'll be around, obviously, too. So.
Well, ask how many people are interested in Kansas.
Well, I know we had a couple.
Okay, you got
Yep.
some.
Yep. All right. We'll get you there. There we go. Fast forward, I guess, if you want to go through.
Thanks. That's fine. All right, with regard to Kansas, let's do some background work first so you kind of can understand what, when you read the case law and what's important to you on your own, you'll kind of be able to put it in context. First context is the person that actually put this together is Brandon Lawson, the Kansas City office. I'm here having saddled him up and ridden him hard over to St. Louis. So he's responsible for putting together the outline, which is a very good outline. Okay. Before the changes in 2011, Kansas the impairment ratings had to be tied to the 4th edition of the AMA guidelines for determining impairment. Now we're under the 6th edition of the guidelines, and you don't think that's probably a very big thing, except the 6th edition squeezes the 4th edition down to very little. And the unintended consequence of that is that we are now seeing a lot of post-award medical hearings that we didn't see before. And one of the reasons we're seeing that is because once an award's been entered, claimant has their indemnity payment, whether it's permanent partial or whatever it is, work disability. If no additional indemnity can be squeezed out of that case, and a post-award medical hearing is basically brought before the court seeking additional medical treatment for when the future medical is left open, claimant attorney can receive a reasonable hourly rate paid for by the insurance carrier. So basically this is another funding source for claimant's counsel now that their impairment ratings are diminishing. And it's amazing to see that. I can tell you the one thing about legislation. It has its intended consequences and it truly has its unintended consequences. And this is one of those unintended consequences. Also, before the change, future medical was basically awarded as a right unless you basically negotiated it closed. So the judges were very, very used to awarding future medical treatment on every award that went to decision. Now, supposedly, future medical is only supposed to be awarded if the need for future medical is more probable than not. You'll find that that's a great statement, but you'll find the administrative law judges particularly sliding back into what's comfortable. And so about any type of evidence that goes into the record of this person will probably need this, whether they do or not, whether it happens or not, the future medical is left open. The third area that has changed is our accident, work-related compensable accident used to be anything that aggravates, intensifies, or accelerates a known condition. So in other words, if we know from x-ray that the person has a tremendous amount of osteoarthritis in the lumbar spine, slips and falls, doesn't really hurt anything, but all of a sudden the osteoarthritis is now symptomatic, the carrier used to pay for the entire amount of the osteoarthritis because it aggravated, it intensified, or it accelerated the condition. We're now under prevailing factor, which means that the accident has to be the prevailing factor in causing the injury and resulting disability. Doesn't have to be the majority, it's just the prevailing. But when you get into cases where there was asymptomatic arthritis, and you have a doctor that says the accident was the prevailing factor because they hurt now and they didn't hurt before, they're still finding that to be compensable, even though we do have a statute that says just because an asymptomatic condition has been rendered symptomatic with the accident, that's not necessarily prevailing factor. In fact, they're saying that's not prevailing factor. But it really doesn't matter because everybody's used to what happened over the last 20 or 40 years. Okay? Now, when you also read these things, understand that Kansas has 5 levels of decision for every workers' compensation case available potentially to the claimant or to the insurance carrier. You have the ALJ. The ALJ gathers the record, the evidence, is basically a god if you admit the compensability of the accident with regard to every preliminary benefit available, whether temporary, total, or medical. Our appeals board cannot take jurisdiction of that case if you agree to compensability at the ALJ level. Unless, of course, the ALJ acts beyond what an ALJ is statutorily supposed to do. So, you admit compensability, you have an issue about temporary total because the claimant testifies, I could do the work that I was doing, I'm not going back to work. If the ALJ says, well, there was restrictions and it's going to be more difficult for him to find a job elsewhere than it was here, I'm going to award temporary total because you basically agreed to compensability at that level. The appeals board won't review that at that point in time. It has to be at the award level, at stage. Now, the ALJ basically has the best job in the world in Kansas because the cases come to him or her. They get to make their decision. They make it on law and facts. They enter their award, and then they go on. If somebody's not happy, and generally one of the parties isn't real happy, it can go to the appeals board as a matter of right. The appeals board basically makes its decision on the law and facts. It can change anything the ALJ did, anyway, anytime, anyhow. It does not take additional evidence. If they think additional evidence is necessary, they remand it back to the ALJ and say, get this evidence. Once the board makes its decision, and here's another little quirk that's kind of fun, the ALJ can basically does not have the entire trial in front of the court in one time. Basically, the claimant comes in and testifies under oath in front of the judge. Then the medical evidence and other witnesses are taken by deposition. So the ALJ generally only sees the claimant testify. The ALJ, though, can make a determination of credibility of any witness based on reading the deposition or seeing the claimant testify. So can the board, but the board doesn't see the claimant testify. The board will make credibility determinations based on a written record. Then it goes as a matter of right to the Court of Appeals, which we finally get into the actual court system out of the administrative agency. The court system, basically the Court of Appeals, only gets to review matters of law. Now you'd think that that means that they would never get into the facts, but they do if they want to. By saying, we have to review this case to see if there's substantial evidence to support the board's decision. Now they also say, and we're not going to get into credibility because that's the board's bailiwick, even though they're reading the same record that the board read. They're not going to get into credibility. Basically what it is they can review what they want to by using the standard that they want to get into a case if they find the case interesting. Okay? Now, then once the appeals board makes its decision, and the appeals board is basically a group of lawyers that appear in 3-member panel. So what happens is, once you start getting further away from the administrative law judge, who I look at as the street level decision maker, you get more consistency from the administrative law judges, but you have to know which judge you're dealing with because there are 10 and they're different people as well. Okay? So it goes from there to a 5-member appeals board. That's where you get the most consistency you can get because 3 out of 5 make the decision. If 3 out of 5 agree, that's the decision. Then it goes to the level of the Court of Appeals, and the Court of Appeals are these 3-member panels that keep changing members. So you don't know who you're going to draw when you get to the Court of Appeals. And then under a writ of certiorari, you can go to the Supreme Court if the Supreme Court deems your case interesting or important enough to deal with. And I can tell you that once you get from the ALJ all the way up to the Supreme Court, you go from street level practicality, knowing who the person is and seeing decisions over and over and over again, to the Supreme Court, who half of them, I'm not sure where they put the apostrophe in workers' compensation. I mean, it could be worker apostrophe S, It could be workers S apostrophe, it could be workmen's apostrophe S by the last time they'd seen the case. And they then become very esoteric or very theory-minded. I can tell you that the Supreme Court in Kansas is one of the more liberal courts in the United States. And you wouldn't believe that if you read about Kansas. But it's there because they know the purpose of workers' compensation and they know why it's there and what it's there for. The problem is you can be operating in workers' compensation for 20 years and then the Supreme Court will finally take a case and then tell you that you've been doing it wrong for 20 years. And it's very difficult at times to come back and learn what you need to do. I'm not sure that we have, I'm sorry about this, but we're not going to probably get into the cases. Does anybody have any questions about any of the cases that are in the handout? If you're not, I would tell you to take a look at when the court talks about credibility and understand what I just told you. And substantial and that type of thing. Substantial evidence and the support there. And I think we're pretty much out of time.
We're probably good, but we'll both obviously be here the rest of the afternoon.
Brandon?
As I said, I'm around too.
Right.
We can put the materials together. If anybody has any questions, I'm happy to be here.
Yeah, please see Brandon if you have any questions as well. Okay?
Want to go